Imagine for a second that you are sitting down to play the most high-stakes board game of your entire life. I'm talking of a situation where there is serious money on the table. Maybe your entire business, your reputation, or your life savings. Everyone is watching. The pressure is immense. But here's the catch. Knowing the strategy, how to actually play your pieces to win, is maybe, I don't know, 40% of the battle.
I'd argue it's even less than that. I mean, if you don't know the mechanics, the strategy is completely irrelevant. You could be a grandmaster at chess, but if you don't know how to set up the board, you can't play.
Right, exactly. Because before you can even roll the dice or move a pawn, you have to master this completely different, incredibly rigid set of instructions. You need to know exactly how to set up the board, exactly when you are allowed to speak, which piece of paper you have to file to even be allowed to sit at the table.
And how to count the minutes until your turn is over. And the terrifying part, if you mess up those pregame instructions, if you miscount the days or file the wrong paper, it doesn't matter if you were morally right. It doesn't matter if the other guy actually stole your money or breached the contract. You lose. Game over. You get kicked out of the room before you even open your mouth to argue your case.
That is the perfect way to describe what we are diving into today. We aren't talking about the flashy stuff you see on TV, how to charm a jury or, cross-examine a weeping witness.
Not at all.
We are looking at the invisible architecture of the American legal system, the federal rules of civil procedure.
It sounds dry, I know. Civil procedure, it sounds like a dusty textbook.
It really does.
But think of it as the operating system of the justice system. Without these rules, the courts are just a room full of people yelling at each other. These rules determine if a case ever sees the light of day.
Specifically, we are looking at the Gateway Rules 3 through 15. This is the mechanics of how you start a fight, which lawyers call pleadings, and the initial moves to stop one, which are motions.
These are the rules that govern the first few months of a lawsuit. It's the gatekeeping phase.
And we have some heavy hitters in the source material today. We aren't just looking at the rulebook text. We are analyzing the landmark Supreme Court cases that completely shifted the landscape of litigation in the last 20 years.
Oh, yeah.
We're talking about cases that fundamentally changed how easy or how hard it is to sue someone in America. Names like Twombly and Iqbal.
Two names that strike fear or absolute joy, depending on which side of the V you're standing on, into the hearts of lawyers everywhere.
So our mission today is to decode this dense legal language into plain English. We want to understand how a lawsuit actually gets off the ground, the rigid structures that keep the legal system from collapsing, and the traps that lay in wait for the unprepared.
And we're going to use concrete scenarios to do it because these rules are so abstract until you see them applied to real problems.
Exactly. So let's jump in. We have to start at the very beginning, the concept of the gateway. The core question here is, how much detail do you actually need to provide just to get your foot in the courthouse door?
This is actually a massive debate in legal theory, and it has shifted, dramatically over time. Historically, the federal rules were known for being somewhat, let's say, welcoming.
Welcoming. The court system. I don't usually hear those two words together.
Welcoming in a procedural sense. You have to remember, before 1938, the legal system was a nightmare of something called common law pleading. It was hyper-technical. If you used the wrong Latin word or put the comma in the wrong place, your case was tossed. It was a game of gotcha.
So the federal rules of civil procedure were created to fix that.
Exactly. They wanted to standardize things, simplify the process. They wanted to shift the emphasis away from the technical paperwork and onto the actual merits of the case. Get to the truth, not just see who had the fancier lawyer.
So under this old-school notice pleading regime, if I wanted to sue you, I didn't need to write a novel.
Not at all. You didn't need to detail every single fact or explain your entire legal theory with perfect precision. You just had to give the other side fair notice of what you were complaining about. The idea was, let everyone in, and we will sort out the details during discovery.
That sounds incredibly plaintiff-friendly. It's basically, hey, I think you wronged me, see you in court.
It was very plaintiff-friendly. The gold standard for this era came from a 1957 Supreme Court case called Conley v. Gibson. The court basically laid down a rule that said a complaint should not be thrown out unless, and this is the key phrase, it appears beyond a doubt that the plaintiff can prove no set of facts which would entitle him to relief.
No set of facts.
Wow.
Wow. That is an incredibly low bar.
It is the lowest possible bar.
It sounds like unless I'm suing you for something physically impossible, like stealing my imaginary dragon or, I don't know, blocking out the sun, I get to stay in court.
Pretty much. If there was even a whisper of a possibility that you had a case, you got to move forward to the next stage, which is discovery.
And we should pause on discovery for a second. Why does getting to discovery matter so much? What is the big deal?
Because discovery is expensive. Extremely expensive. That's where you get to force the other side to hand over emails, internal memos, financial records. You get to depose their CEO. It costs companies millions of dollars to comply with discovery.
So under the old rules, you could file a somewhat vague lawsuit, and the company might settle just to avoid that cost.
Exactly, the nuisance settlement.
Right.
But then the vibe changed. The courts started getting clogged, discovery got even more expensive with the invention of email and electronic data, and the Supreme Court decided it was time to tighten the screws. We entered what we call the plausibility era.
This is where things get really interesting, and where the sources point to a massive pivot. In the last couple of decades, the Supreme Court decided that fair notice wasn't enough anymore. It started with a case called Bell Atlantic Court v. Twombly in 2007.
Twombly. It sounds like a cartoon character, doesn't it? But this was a massive antitrust case involving huge telephone companies.
Okay, set the scene for Twombly. What happened?
So this was right after the breakup of the classic telephone monopolies. The plaintiff and Twombly claimed that these big telephone companies, the baby bells, were conspiring to restrain trade. They pointed to the fact that these companies were acting in very similar ways.
Similar how?
Well, they weren't competing in each other's territories. Company A stayed in the Northeast, Company B stayed in the South. The plaintiff said, look, they're all doing the same thing. They aren't fighting each other. They must have a secret agreement. They must have sat down in a smoke-filled room and agreed to carve up the map.
And under the old Conley rules, the notice pleading rules, that probably would have been enough to get to discovery, right? Because it is possible they conspired.
Exactly. Under Conley, you'd say, well, I can't prove there isn't a conspiracy yet, so let me look at their emails. But the Supreme Court in Twombly said, stop. They ruled that stating a possible claim isn't enough anymore. You have to state a plausible claim.
Plausible versus possible. That sounds like a synonym game, but it was a huge legal shift. What is the difference?
The court said you need enough facts to nudge your claim across the line from conceivable to plausible. In Twombly, the court looked at the behavior of the phone companies and said, sure, they are acting similarly, but that is also exactly how companies act when they are just making smart economic decisions independently.
Like gas stations on a corner.
Perfect example. If one gas station raises its price, the one across the street raises theirs too. Are they conspiring? Or are they just reacting to the market? The court said that just behaving similarly, what they call parallel conduct, wasn't enough to prove a conspiracy. It was just as likely they were acting independently.
So without a smoking gun, without an email saying, let's collude.
Right. Without more specific facts, like a whistleblower or a specific date of a secret meeting, the lawsuit died right there. The court effectively said, if your story has two explanations, one illegal and one innocent, and you don't have facts to rule out the innocent one, you don't get to play.
That is a much higher hurdle. And then, just to make sure everyone knew they were serious, the court doubled down a few years later with Ashcroft v. Iqbal.
Iqbal was a totally different animal. Twombly was about corporate money. Iqbal was a constitutional tort case. A detainee after 9/11 sued high-ranking government officials, including the Attorney General, claiming discrimination based on race and religion.
Right. And at the time, many lawyers thought, okay, Twombly was just for antitrust, because antitrust discovery is super expensive. It won't apply to civil rights cases.
But they were wrong. In Iqbal, the court applied the Twombly standard again. The plaintiff said the government adopted a policy to discriminate. The court looked at the complaint and said, is that plausible? Or is it more likely that the government was aggressively investigating a terror attack and the arrests happened to impact certain groups disproportionately?
They went with the innocent explanation again, or at least the non-discriminatory one.
They did. They said the plaintiff didn't state a claim that was plausible on its face. And the big takeaway from Iqbal was that this standard applies to all federal civil cases.
So it gave district judges way more power.
Massive power. It gave judges what we call judicial discretion to look at a complaint early on and say, I don't buy it. This doesn't make sense based on common sense and experience. Dismiss.
So let's ground this for the listener. Let's create a scenario to see the difference between the old way and the new way.
Great idea.
Let's say I own a lemonade stand, and you open a lemonade stand right across the street, and suddenly my sales tank. I want to sue you for unfair business practices.
Okay, let's apply the rules. Under the old Conley notice pleading standard, you could probably file a complaint that just says, the expert opened a stand and is hurting my business unfairly. I want damages.
Short, simple. I'm putting you on notice that I'm coming for you.
Right. And that probably would have survived. The judge would say, well, maybe he did something unfair. Let's find out. You would get to discovery.
But under the new Twombly and Iqbal standard,
That gets thrown out immediately because hurting my business unfairly is just a conclusion. It's a legal conclusion masquerading as a fact. You are just saying it's unfair. But competition is legal. To survive now, you would need to allege specific facts.
Facts like what?
You'd have to say something like, on July 12th, the expert dumped salt in my sugar supply, or the expert paid people to stand in front of my driveway and block customers. You need the who, what, where that makes the claim plausible, not just a vague accusation that I'm being mean.
So we moved from, hey, just letting you know I'm suing you, to here's exactly why this story makes sense and here are the specific incidents.
Precisely. It front-loads the work. You have to do your investigation before you file the suit.
Which brings us to the document itself. When you were drafting this complaint, you can't just write a letter to the judge. Rule 8 gives us the recipe.
The ingredients list. According to Rule 8A, there are 3 essential ingredients for any complaint. If you miss one, you are out.
What's ingredient number 1?
First, you need a short and plain statement of the grounds for the court's jurisdiction.
Which basically means here is why this specific court has the power to listen to me.
Right. You can't just walk into any court. Federal courts are courts of limited jurisdiction. They can't hear everything. They can't hear a speeding ticket case, usually. They can't hear a standard divorce. You have to prove they have the authority, subject matter jurisdiction. You have to affirmatively state it in the first paragraph.
Okay. Ingredient number 2.
Second, you need that short and plain statement of the claim showing that the pleader is entitled to relief.
And that's where our friend plausibility lives.
Yeah.
That statement is where you have to pass the Twombly-Iqbal test we just talked about.
Correct. That's the meat of the sandwich.
And ingredient number 3.
A demand for judgment.
What do you want section?
Exactly. Do you want money? Do you want an injunction in order to stop the other person from doing something? You have to ask for it. And interestingly, Rule 8 allows you to plead in the alternative.
Explain that. Relief in the alternative. What does that mean?
It means you don't have to pick just one outcome yet. You can say, Judge, I want the car back. But if you can't give me the car back because you destroyed it, then I want $50,000.
So plan A or plan B?
Yes. You can even state separate claims that are legally inconsistent. This confuses people. You can say, Claim 1, I never signed that contract. And then say, Claim 2, but even if the court finds that I did sign the contract, I didn't breach it.
That feels like talking out of both sides of your mouth. I didn't do it, but if I did, it wasn't bad.
It is, but the rules allow it because at the start of a case, you don't know exactly how the evidence will shake out. You are allowed to cover your bases.
Now, Rule 8 says short and plain. But there is a catch, isn't there? Sometimes short and plain doesn't cut it.
That is where Rule 9 comes in. I like to call this the zoom-in rule. There are certain accusations that are so serious or so reputationally damaging that the federal rules require you to be extra specific. You have to plead with particularity.
The big one here is fraud, right?
Fraud or mistake. If you are going to accuse someone of fraud, you cannot be vague. Calling someone a fraudster puts a stain on their reputation that is hard to wash off. So Rule 9b demands that you state the circumstances constituting the fraud with particularity.
You need the reporter's notebook. Who, what, when, where.
Exactly. You can't just say he lied to me. You have to say, on Tuesday, in an email sent at 4:00 p.m., he stated the car had 50,000 miles when he knew it had 150,000.
But here's where it gets really interesting, almost ironic. While you have to be super specific about the act of fraud, Rule 9 says you could be totally general about the person's mindset.
It does seem contradictory at first. Rule 9b says malice, intent, knowledge, and other conditions of a person's mind may be alleged generally.
Why the difference? Why do I have to be Sherlock Holmes on the act, but I can be vague on the brain?
It's a practical reality. It is very easy to point to a specific document or a specific lie and say, that happened on Tuesday. But how do you prove what was inside someone's head at the very beginning of a lawsuit? You haven't done discovery yet. You can't read minds. You can't see the neurons firing.
You don't have their diary yet.
Exactly. So the courts let you allege intent generally. You can say he did it with malice, knowing you'll have to prove that mindset later with evidence. But you have to pin down the lie itself immediately.
Let's do another scenario to lock this in. Let's go back to real estate.
Okay, I love a real estate disaster.
Scenario A. I buy a house from you, and after I move in, the roof leaks. I want to sue you for breach of contract because the contract said roof is good.
That falls under Rule 8. You just need a short, plain statement. We had a contract, you promised the roof was good, it leaked, I want damages. Standard pleading. Plausible. Simple.
Okay, scenario B. I buy the house, and I find out the walls are full of termites. But I also find out that on July 4th, you personally went into the house and painted over the termite damage to hide it from me.
Ah, see, now you are accusing me of fraud. You are saying I tricked you. Now Rule 9 kicks in.
So I can't just say the seller defrauded me.
No,
Right.
that would be dismissed. You have to write. On July 4th, the defendant used white paint to cover termite tracks in the living room to conceal the defect. You need the specifics of the deception. If you don't include that detail, your fraud claim gets dismissed.
And what if that fraud caused me to have a nervous breakdown and I had to miss work?
Now you're talking about special damages. This is Rule 9G.
What's the difference between general and special damages?
General damages are the obvious ones, like the cost to fix the roof. Everyone knows a leaky roof costs money. You don't have to explain that. Special damages are ones that don't naturally, obviously flow from the event.
So me losing my job because I was so stressed about the termites? That's not obvious.
Not at all. That is specific to you. If you want to claim that, you have to list it specifically in the complaint. You have to warn the defendant, hey, I'm coming for your money for the roof, A&D for my lost wages. You can't blindside them at trial with $1 million claim they didn't know was coming.
Okay, so we have drafted our complaint. We have been plausible. We have been specific where we need to be. Now we have to actually start the case. This brings us to the stopwatch.
Time is everything in law. Missing a deadline is the #1 way lawyers get sued for malpractice.
Rule 3 tells us when the race starts. It says a civil action is commenced when the complaint is filed with the court clerk.
Simple enough. I drop it off at the courthouse, stamp it, clock starts.
Usually. But, and there is always a but in law. What if we are in federal court because of diversity jurisdiction?
Okay, quick recap on diversity jurisdiction. This is when you are in federal court, not because of a federal law, but because the parties are from different states and there's a lot of money at stake, over $75,000.
So a New Yorker sues a Texan for a car crash.
Right. In that case, the federal court is basically acting like a state court. They are applying state law for the substance of the case.
And this creates a trap.
A massive trap. The Supreme Court case, Walker v. Armco Steel Corp., tells us that in diversity cases, state law decides when the clock starts for the statute of limitations.
So let's play this out. Federal Rule 3 says filing starts the case.
Yeah.
But let's say the state law says the case doesn't start until you actually hand the papers to the defendant.
Which is common. Many states require service of process to stop the statute of limitations clock.
So imagine the statute of limitations runs out on Friday. You run to the federal court and file the papers on Friday. You think you're safe because of Federal Rule 3.
You wipe the sweat off your brow. You think you made it. But if the state law governs and you don't serve the guy until Monday, you're too late. Case dismissed. You lost because you relied on Rule 3 instead of state law.
That is terrifying. It's a mix and match problem.
It is. Always check the state law in diversity cases.
Now, speaking of counting days, Rule 6 seems like something that trips people up constantly.
It does. It sounds simple. Count 21 days. But how exactly do you count? Rule 6A gives us the standard method.
Rule number 1, don't count the trigger day.
Right. If you are served with a lawsuit today is day 0. You start counting tomorrow. Think of it like a birthday. You don't turn 1-year-old the day you were born.
What about weekends? Do we get to skip those?
You count them Saturdays, Sundays, legal holidays. They all count towards the total. It's a running clock.
So if I have 21 days, I count the Saturdays and Sundays in between.
Yes.
But what if the deadline, the finish line lands on a Sunday? The court isn't even open.
Then you get a break. If the last day is a Saturday, Sunday, or legal holiday, the deadline extends to the next business day.
So if my deadline is Sunday, I can file on Monday.
Correct. They don't penalize you.
And there is a little bonus for modern technology, isn't there? A sort of grace period.
There is. Under Rule 60, if you are served electronically, email, e-filing, or by mail, you generally get 3 extra days added to the prescribed period to respond.
That's generous. A little email buffer.
It is, but don't bank on it unless you are sure. So, to recap the stopwatch, start by filing, usually. When counting, skip day 1. Count every weekend. If you end on a Sunday, bump it to Monday.
Got it. So the complaint is filed, the clock is ticking, now the ball is in the defendant's court. And this is where the strategy really heats up. The defense strikes back.
This is Rule 12. This is the shield. Before the defendant even tells their side of the story, before they file an answer, they can try to get the whole case thrown out.
The pre-answer motion is like saying, Judge, we don't even need to argue about the facts because this lawsuit is broken.
Exactly. The most famous one, the one you learn on day one of law school, is Rule 12b-6. Failure to state a claim upon which relief can be granted.
So what motion?
That's the perfect name for it.
Yeah.
The defendant is arguing, even if everything the plaintiff wrote is 100% true, there is no law that makes me liable.
Can you give us an example?
Sure. Suppose you sue me because I gave you a dirty look at the grocery store. You write a beautiful complaint, detailed, plausible facts. He looked at me with a frown at 3:00 p.m. in the produce aisle.
And I want $1 million for my emotional distress.
I would file a 12b-6 motion. I'd say, Judge, assume I did frown at him. Assume I frowned really hard. So what? Giving someone a dirty look isn't a tort. It's not illegal. The judge dismisses it immediately.
Because even if it's true, the law doesn't care.
Exactly. And importantly, under a 12b-6 motion, the judge generally looks only at the complaint itself, right? They don't look at outside evidence. This is called the four corners rule.
They stay within the four corners of the document.
Right. If the defendant tries to say, but Judge, I have a video showing I was smiling, the judge will say, not yet. We assume the plaintiff is telling the truth for now.
What if the defendant insists on showing that video or an affidavit?
If the judge decides to consider that outside evidence, the rules say the motion must be converted into a motion for summary judgment under Rule 56. And that changes the whole procedure. Everyone has to be given a chance to present all their material. It slows things down.
Okay, now sticking with Rule 12, there's a massive trap here for defendants, the waiver trap. This is crucial.
This is where you lose the game on a technicality. There are certain defenses that are use it or lose it.
What are they?
Specifically, lack of personal jurisdiction, improper venue, insufficient process, and insufficient service of process.
These are the technical objections. You're in the wrong state, or you didn't hand me the papers correctly.
Correct. Rule 12 is very strict. You must raise these objections in your very first response, whether that response is a motion to dismiss or an answer.
Give me a scenario where someone messes this up.
Okay. You are sued in New York, you live in Texas, you have never been to New York, the venue is clearly wrong, you hire a lawyer. The lawyer files a motion to dismiss, arguing that the complaint is vague, that's a 12b-6 motion, but the lawyer forgets to write a section arguing improper venue.
So they argue the merits, but forget the location.
Right. The judge denies the motion. Then the lawyer says, oh wait, also my client lives in Texas, we shouldn't be here.
What does the judge say?
The judge says, too late. You waived it. You are stuck in New York now. You accepted the court's authority by arguing the merits without objecting to the location first. You implicitly consented.
Ouch. Is there any exception? Is there anything you can't waive?
Yes. Subject matter jurisdiction.
That's the court's actual power to hear this type of case.
Right. Remember we said federal courts are limited. If a federal court hears a divorce case, which is a state matter, they literally do not have the power to issue a judgment.
Even if everyone agrees.
Even if everyone agrees. You can raise a lack of subject matter jurisdiction at any time. You could go through the whole trial, lose, and then on appeal say, hey, the federal court never had jurisdiction. If you're right, the whole judgment gets wiped out.
Wow. So procedural defects, like venue,
Yeah.
raise them immediately or die. Jurisdictional power, raise whenever.
Exactly. It's a hierarchy of importance.
Okay, let's say the defendant tries a Rule 12 motion, and the judge says, nice try, but denied. The complaint is plausible. Now what?
Now you have to face the music. You have to file an answer.
This is Rule 8b. The timeline is usually 21 days after being served. Or if you lost your motion to dismiss, you usually have 14 days to file the answer. But let's talk about the content. You have to go paragraph by paragraph.
It is tedious but essential. The plaintiff's complaint is numbered. Paragraph 1, paragraph 2, etc. Your answer must match that. For every allegation, you have 3 options. Admit, deny, or state that you lack knowledge or information sufficient to form a belief.
Admit means, yes, that's true. Deny means that's a lie. Lack of knowledge means I honestly don't know.
But be careful with lack of knowledge. You have a duty to investigate reasonable information. You can't just play dumb if the answer is in your own files.
What happens if I just skip a paragraph? Say I just get lazy and forget to address paragraph 12.
That is a disaster. Under the rules, if you fail to deny an allegation, it is deemed admitted.
Silence implies consent.
In the world of pleadings, absolutely. If the plaintiff says, the traffic light was red and you say nothing, the court treats that as you admitting the light was red. You can't fight it later.
Is there any exception?
Yes, the amount of
Oh.
damages. You don't accidentally admit that you owe $1 million just by not denying the number, but the facts of liability. If you don't deny it, you've admitted it.
That is high stakes. Now, the answer isn't just about defense. It's also where you can go on the offensive.
Right. This is where we see affirmative defenses. These are the yes, but arguments.
Yes, I hit your car,
But the statute of limitations has passed. Or, but you assumed the risk by walking onto the construction site. Or, res judicata, meaning this has already been decided in another court.
Rule 8C has a laundry list of these. Fraud, duress, payment. Why do these have to be in the answer?
Same reason as the Rule 12, motions, fairness, and notice. You can't surprise the plaintiff at trial by saying, oh, by the way, this claim expired 3 years ago.
Yeah.
If you don't raise an affirmative defense in your answer, it is generally waived. The trial is supposed to be about the facts in dispute, not secret legal trapdoors.
And what if I want to sue you back?
That's a counterclaim. If you have a claim against the plaintiff, you put it in the answer. In fact, if your claim arises from the same transaction or occurrence, the same car crash, the same contract dispute, you must file it as a compulsory counterclaim.
If I don't?
You lose the right to sue on it later. You can't save it for a separate lawsuit. The system wants to resolve the whole mess in one go.
So it's efficient. Okay, so we've got the complaint, the motion to dismiss, and the answer. The board is set. But people make mistakes. Lawyers make mistakes. New evidence comes to light. What if I filed my complaint and then I realize, oh shoot, I forgot to add the fraud claim, or I sued the wrong guy?
That brings us to Rule 15, amendments. The rules are actually pretty forgiving here. They understand that litigation is a process of discovery. We don't want to punish people for learning new things.
There was a freebie amendment, right?
Yes. You can amend your pleading once as a matter of right within 21 days of serving it. Or if the other side has already filed a responsive pleading or a Rule 12 motion, you have 21 days after that service to fix your mistakes without asking anyone.
So if you file a motion to dismiss pointing out all the holes in my complaint, hey, you forgot to allege jurisdiction, I have 21 days to say, you know what, you're right, let me rewrite that.
Exactly. And often that's what happens. It saves the court time. Instead of the judge ruling on a flawed complaint, you just fix it.
But what if 21 days have passed?
Then you have to ask for permission. You need leave of court. But Rule 15A2 has a very famous instruction to judges. The court should freely give leave when justice so requires.
So they usually say yes.
They usually say yes. The bias is towards letting the case be heard on the merits. They will only say no if it would genuinely hurt the other side, what we call prejudice, or if the amendment is futile.
Futile means pointless.
Right. If you're trying to add a claim that is clearly legally bogus, the court will say, we aren't going to waste time adding a claim that we would just dismiss 5 minutes later.
Now, here is a concept that sounds like science fiction. Relation back.
Time travel for lawyers. This is vital when you are up against the statute of limitations.
Let's do a scenario to explain this. This is tricky.
Okay. Imagine the statute of limitations for your injury runs out on December 31st.
Okay. Deadline is New Year's Eve.
You file your lawsuit on December 1st. You are safe. You are in on time. But then, in February, after the deadline has passed, you realize you left out a claim for negligence regarding the same accident. You want to add it to the lawsuit. Technically, you are too late for that new claim. The date is past December 31st.
Technically, yes. I am attempting to file a new claim after the bell has rung.
But Rule 15C saves you. It says that if the new claim arises from the same conduct, transaction, or occurrence as the original complaint, the law treats it as if it were filed on the original date, December 1st.
It relates back to the safe date.
Exactly. Why? Because the defendant already knew about the incident. They aren't being surprised by a totally new event, just a new legal theory about the same event. They have been on notice since December 1st.
What if I try to add a totally different event, like, oh, also he punched me 5 years ago?
That won't relate back. That's a new occurrence. That would be time-barred.
What if I sued the wrong person? Can I swap in a new defendant after the deadline?
That is much harder. Rule 15C1C allows it, but only if strict conditions are met. The new defendant must have received notice of the action within 90 days of the original filing.
Oh.
And this is key. They must have known that, but for a mistake, they would have been sued.
So if I sued Target Corp., but I should have sued Target Stores, Inc., and the lawyers for Target knew about the mistake.
That usually works. It's a misnomer. But you can't use this to just fish for new defendants you didn't know about. Oh, I didn't know John Doe was involved. Let me add him now.
Oh.
That usually doesn't relate back. It
Huh.
really has to be a case of mistaken identity.
All right, we are in the home stretch. We have talked about the mechanics, the strategy, the timing, but we haven't talked about the referee's whistle. What keeps lawyers from lying or filing frivolous paperwork just to harass people?
Rule 11. This is the integrity check. This is what stops the system from becoming a total circus.
Rule 11 deals with the signature on the document. It's not just an autograph.
No. Under Rule 11b, every time an attorney or a person representing themselves signs a document and presents it to the court, they are making a certification. They are promising three main things.
Number one.
No improper purpose. You aren't filing this just to harass someone, cause unnecessary delay, or needlessly drive up the cost of litigation. You can't sue someone just to annoy them into settling.
Number two.
The legal arguments are sound. They are warranted by existing law.
Can you argue to change the law?
Yes, you can argue that the existing law is wrong and should be reversed. That is how civil rights progress happens. But it has to be a non-frivolous argument. You can't just make up laws that don't exist or argue things that are total nonsense.
And number three.
The facts. You certify that your factual contentions have evidentiary support or will likely have support after discovery. You can't just invent facts.
So if you lie or file a garbage motion, you can be sanctioned.
Yes, the court can punish you. But, and this is a fascinating procedural quirk, there is a safe harbor.
Explain this. If I catch you violating Rule 11, say you filed a motion that is totally frivolous, I can't just run to the judge immediately.
No. If I draft a motion for sanctions against you, I have to serve it to you first. But I cannot file it with the court yet. I have to wait. I have to give you 21 days.
The 21-day cooling-off period.
It's a fix-it period. During those 21 days, you can withdraw the offending document or correct the mistake. If you fix it, I can't file the sanctions motion. The problem goes away. No harm, no foul.
So you can effectively say, whoops, caught me, take it back, and avoid punishment.
Exactly. The goal of Rule 11 is deterrence, not punishment. It's not about gotcha. It's about keeping the docket clean. If you withdraw the bad filing, the system is satisfied because the bad document is gone.
And if they don't withdraw after 21 days?
Then you file the motion and the court can impose sanctions.
Does that mean you get paid?
Not necessarily. The sanctions can be non-monetary directives, like making the lawyer take a legal ethics class, or penalties paid to the court. In rare cases, the court might order the bad actor to pay your attorney's fees, but that is the exception, not the rule.
So the focus is on stopping the behavior, not making the other side rich.
Correct. The sanction is limited to what suffices to deter repetition. It's a sharp slap on the wrist, not usually a death sentence.
Wow. We have covered a massive amount of ground today. We started with a shift from the fair notice days of Conley
to the strict plausibility of Twombly and Iqbal.
We walked through the kitchen of drafting a complaint with Rule 8 and Rule 9, and we watched the stopwatch with Rule 3 and Rule 6.
We learned how to dodge the waiver trap of Rule 12, how to file an answer with affirmative defenses, how to use time travel to fix our mistakes with Rule 15.
And finally, how to promise to tell the truth under Rule 11.
It is a complex dance, but these rules are what make the system function. They balance the plaintiff's right to be heard against the defendant's right not to be dragged into court on a whim.
So what does this all mean for you, the listener? Whether you are a law student prepping for finals, a business owner worrying about liability, or just someone fascinated by how society works, understanding these rules reveals the invisible architecture of justice. It's not just about who is right, it's about following the process that ensures fairness.
Absolutely. If you ignore the rules, you lose the right to the argument.
But before we go, I want to leave you with a thought about that safe harbor in Rule 11. We said the goal is deterrence. But think about the incentives there. Does giving lawyers a free pass to withdraw a frivolous motion actually encourage them to try their luck?
That is the big question. If I know I can just take it back if I get caught, why not try a crazy legal argument? Why not push the envelope? Does the safe harbor actually encourage sloppy or aggressive lawyering because the risk is so low?
It's the difference between a penalty that happens instantly versus a warning shot, something to mull over. Thanks for joining us on this deep dive into the federal rules.
Always a pleasure.